Next.
Judge, we can start with Mr. Richard Peck.
Richard Charles Peck Junior, CR 25281. Mr. Peck is set for pretrial.
Judge, I believe at our last setting, I had relayed to the court that I have been in contact with the DA's office requesting officer information for an officer who is no longer employed by the Wills Point Police Department, who was the lead investigator in this case. I have sent three requests for that information, and at this time have not received a response. It's my client's wish to go ahead and set that for jury selection, and go ahead and get on the jury selection docket for this case.
Any response from the state?
Your Honor, I'm working off third-hand or second-hand information, so forgive me if I'm not 100% accurate. My understanding is that there was a response, but did not contain certain information that Mr. Manning was asking for that we don't have at the office. Is my understanding of the nature of the response.
Mr. Manning, can you elaborate on that?
Yes, Judge, just for a moment. Judge, on March 4th, I made the initial request for under both a public information request and under 3914 and Brady for information regarding Dawn Wheeler's surrender of her peace officer's license. I made that request in a timely fashion under Chapter 552. There then on March 17th seemed to be some confusion as to what my request was. I clarified that on March 17th and received a response on March 23rd saying that the office had no documents and that they had not requested a copy of her personnel file from Wills Point Police Department, but said they would request it in the future. I then submitted a additional reiteration of my request on March 25th regarding any and all mitigating exculpatory information regarding Dawn Wheeler, as well as a full, current, and unredacted copy of the office's Brady list. And at this point in time, I have not received a response from the DA's office.
Right. And so, Mr. Harwell, if I understand you to say the DA's office does not have, does not possess any of that, those documents in its evidence or in its file, and that y'all have not requested that from the arresting agency.
Your Honor, as far as personnel file, my understanding is that no, we don't have Detective Wheeler's personnel file here. As far as what's actively being worked on, requested, I don't have an updated information for the court. This isn't something that I've personally been working on. I apologize that I don't have a more detailed answer for the court.
And Judge, I'm sorry, I should have clarified at the beginning. These emails are between myself and Ms. Curry, as she was the one that responded to my initial request.
Okay. All right. Well, we're at pretrial now. Do you want me to go ahead and place you on the jury trial docket, or do you want me to reset for another pretrial? Do you want to subpoena somebody from the Wills Point Police Department for a
Judge,
hearing?
in my communications with Wills Point Police, with the city of Wills Point, it was my understanding that the decision to surrender the license came from the DA's office. It was not a decision made by the Wills Point city or police department, and so therefore, I don't believe they have the information that I am requesting. And so we will go ahead and request it be set for jury selection.
So you said that you're seeking a surrender of a. I guess I'm unclear. You said it wasn't the Wills Point Police Department or the city of Wills Point's decision to surrender a license, meaning like produce a license, or have a police officer surrender a license?
To have the police officer, Miss Wheeler, surrender her license.
I guess I'm not quite following that. What
As I said, I think this would be we would be able to get this handled by getting officer or Miss Wheeler on the stand and having her testify at trial. I believe all those issues would be cleared up at that point in time.
But you don't have the documents before trial to prepare with. Is that not the
I
issue?
I don't have the documents from the DA's office, but I believe I have sufficient information to go forward at this point.
Okay, so you're waiving the request of those documents from the DA's office at this time.
No, Judge, if they do aren't responsive to my last request on March 25th, I still would request those documents from the DA's office. But after discussing with my client, he and I are in joint agreement to go ahead and set it for jury selection at this time.
Okay. All right, court will set Mr. Peck for jury selection beginning April 6th. He'll remain on the court's rolling trial docket until his case is called for trial. And I presume, Mr. Manning, that there was either no offer or regardless of the offer, it's rejected.
That's correct, Judge.
All right. And was an offer made to Mr. Peck?
I believe there was one, Judge, but as my client is asserting his innocence, that offer has been rejected.
I'd like to go ahead and know what that offer is. That way Mr. Peck doesn't later show up and say, well, I didn't know about that offer, or I would have taken that. I'd like to
Yes,
know.
yes, yes, Judge. Judge, I'm actually, I may have been thinking of another case, but I don't show, at least on my email, that we received an offer. Let me check one more spot.
And if I could interject, Your Honor, I didn't see one in my email or the case notes. My recollection is that we began discussing the case, but never got around to making an offer. When we discussed it, discussions of offers were put on hold.
Okay. All right. I'm satisfied with that. So all offers, regardless of what they would have been, even if it would have been a Class C misdemeanor, all those have been rejected. So court places Mr. Peck on jury selection April 6th. And I'll notify you once he gets in the top 10, Mr. Manning.
Thank you, Judge.
Who would you like next?
Judge, next ready on Mr. Michael Baker.
Mr. Baker, you'll come forward, please. This cause number CR 26-7, State versus Michael Glenn Baker, set for arraignment.
Yes, Judge. My client has reviewed the indictment. He understands the charge against him as well as the punishment. His name is spelled correctly. He pleads not guilty. Request to be set on the pretrial docket for us to receive discovery and discuss defenses.
All right, Mr. Manning, do you want to set it on? We can either do. I don't have very many Thursdays available. Only one available in May, so I can set later this month, either the 23rd, which is 1, 2, 3, 4, 3 weeks from today, or we can set it on the 30th on that evidentiary docket.
Judge, while we're working out the discovery accommodations here at the jail, if we could set it for the 30th so I can have some more time to.
Sure. All right, court sets Mr. Baker for pretrial on April 30th. At 1:30, should you make bail, hearing will be at 9 a.m.
Judge, I was appointed on Mr. Bates' case today. I went over a copy of the motion to adjudicate, which was filed in January 2026, and request to be set in the April 30th docket for us to discuss possible resolutions and getting Mr. Bates back on track.
All right, court in cause number CR 25-118, State versus Christopher Robin Bates, sets Mr. Bates for hearing on April 30th. Who's next, Mr. Manning?
Judge, next, ready on Mr. Douglas Maine.
Mr. Maine, if you'll come forward, this is cause number CR 26-2, State versus Douglas Ray Maine on pretrial. This is also
Yes,
cause
Judge.
number CR 26-3.
At this time, we have no contested pretrial issues. We have received an offer. However, I plan on presenting a counter offer to the state after today's hearing. We'd request this time set for docket call.
All right, court sets Mr. Maine for docket call on April 30th. In each case, 1:30.
Judge, next ready on Mr. Larry McCain.
Larry Dean McCain, CR 25-280. And Mr. McCain is set for Dr. Call.
Yes, Judge. You're gonna ask this. So let me look up real quick our last offers we received on.
You mean to tell me, Mr. Manning, that you're starting to see a pattern?
After a few years, yes, sir. I don't believe we had actually reached the point of getting an offer due to my client's aim of self-defense in the situation. I just don't think we ever were able to reach an agreement with the state. So correct me if I'm wrong, Mr. Hartwell, but I don't believe we have an offer on Mr. McCain's case.
Correct. We've been working on it. Part of the issue is there may be some, and if I've got cases confused, please correct me, but there may be some surveillance video that you were looking for that a third party, a private party may have. You were unable to locate that.
That's right.
I was putting in some inquiries as well, and so far I haven't been able to get a hold of anything either. But our discussions on offers was kind of put on hold, waiting to see if we could find the potential of surveillance video.
And Judge, I think at this point, just because my client's in custody, I will continue those efforts of negotiation. But due to the length of the trial list and because of the serious nature of the offense, I think my client and I have reached a point where we are ready. Even it would, despite not having some of the best evidence that we could hope for, which is that video evidence, I think he is ready to proceed to jury selection without the need for any additional negotiations or offers.
Understand. Court places Mr. McCain on the jury selection docket for April 6th and may not allow the defendant to engage in further plea negotiations.